Welcome to This Explainer. Today, we're going to dive into a truly fascinating constitutional case that proves dismantling systemic injustice is, well, almost never as simple as just erasing words from a page. You see, when a society undergoes a massive transformation, it inherits this incredibly tangled web of old rules. And untangling that web without breaking the systems that everyday people rely on, that's an incredibly delicate operation. So we are looking closely at how the Constitutional Court of South Africa navigated exactly this kind of crisis in the landmark case of Moseneke v. the Master of the High Court.
Let's actually kick things off with this profound thought from Justice Sachs. It perfectly captures the tension between constitutional idealism and everyday, on-the-ground administrative reality. You know, when a new democratic constitution is adopted, you might think all the bad laws immediately vanish in a puff of smoke. But as Justice Sachs notes, transition is a deeply practical process. We're going to explore exactly why sweeping change can't just happen with the stroke of a pen, and what actually happens when the law tries to move way faster than the bureaucracy can handle.
Section 1. A family's shocking discovery. To wrap our heads around this massive legal puzzle, we really need to start with a deeply personal story. Systemic issues always start with real people facing real barriers, right? And the situation we're exploring today was sparked by a grieving family who were literally just trying to settle their late father's affairs. In October 1999, a retired principal and inspector of schools, Sedise Moseneke, passed away without a will. He left behind a widow, a retired schoolteacher, and 4 sons, all of whom were highly educated professionals, leading what they described as an urban lifestyle. Mr. Moseneke's estate was substantial. We're talking immovable property, motor vehicles, shares, unit trusts, insurance policies, the whole shebang. Like anyone in their position, the family just wanted to handle his estate properly and professionally.
So they did what you'd expect. The family naturally assumed the master of the High Court would handle the estate, because that's the standard procedure. They had their attorneys lodge a death notice and forward a whole host of documents to the master. But then they suddenly slammed into this huge bureaucratic wall straight out of the apartheid era. To their utter shock, they found out, not even from the master, but from a local magistrate, that the magistrate had taken over the administration of the estate.
Let's move on to Section 2, the legacy of 1927. Now, the family hadn't made a paperwork error, not at all. They had literally collided with a ghost from the past, the Black Administration Act of 1927, a piece of legislation fundamentally at odds with a democratic South Africa. They were ensnared by this law, which was specifically designed to enforce segregation and treat black citizens as subjects to be administered, rather than, as people with equal rights. The Constitutional Court itself described this act as an egregious apartheid law. It was this anachronistic survival from a shameful past, built to systematically disadvantage a majority population by stripping away their civil rights in favor of a totally separate subordinate administrative track.
This brilliantly illustrates just how absurd and demeaning this bifurcation of the law actually was. It meant that if a white, colored, or Indian person died without a will, their estate was automatically handled by the Master of the High Court. But for black individuals who died without a will, a specific clause, Section 23(7) of the Act, actively prohibited the master from dealing with their estates. Instead, under Regulation 3(1), black intestate estates were forced right into the hands of local magistrates.
Refusing to accept this indignity, and who could blame them? The Mosenekes took the matter to the High Court, challenging the regulation that empowered the magistrate. Their attorneys wrote to the master expressing serious concern over being subjected to differential treatment, strictly based on race. When the master reported that his office simply did not have the jurisdiction to help under the existing laws, the family sued. They asked the court to strike down Regulation 3(1) so they could be treated like any other citizens.
Section 3. The unintended administrative chaos.
Okay, this brings us to the twist in our story, where a seemingly victorious legal ruling accidentally caused an absolute catastrophe. It's a perfect example of why dismantling old systems requires surgical precision. At first glance, the High Court striking down the racist regulation looks like the happy ending we all want, right? The judge looked at the draft order presented by the family, agreed the regulation was unconstitutional, and declared it entirely invalid. Boom, the racist regulation was dead.
But here is the crucial point. The lawsuit failed to challenge Section 23(7) of the Act itself. This meant that, while the magistrates were stripped of their power to administer these estates, the Master of the High Court was still legally banned from stepping in to fill the void. So, the High Court had inadvertently created a massive legal vacuum.
This triggered an immediate administrative impasse, where roughly 66,000 estates were instantly frozen. 66,000. Just think about that number for a second. With no official procedures in place, authorities couldn't be issued, properties couldn't be transferred, and financial institutions straight up refused to release funds. Suddenly, grieving black families all over the country couldn't even access the money needed to pay for their loved ones' funerals. The Master's office reported that absolute chaos had ensued.
Which brings us to Section 4, the constitutional dilemma. This crisis landed directly on the desk of the Constitutional Court. The situation had escalated from one family's fight for dignity to a full-on nationwide administrative collapse. I want you to consider this for a moment. Put yourself in their shoes. How do you respect the fundamental rights guaranteed by a new constitution and cleanse the statute books of a deeply racist law while simultaneously keeping the gears of society turning for thousands of vulnerable people?
They had to weigh the immediate constitutional demand to uphold human dignity against the Master's stark warning that his office completely lacks the human resources, infrastructure, and finances to suddenly absorb thousands of estates. It was a brutal clash between ending demeaning differential treatment on one side and the harsh reality of practical governance on the other. Actually, scratch that. It wasn't just a challenge. Transferring 66,000 estates overnight would completely obliterate the Master's offices.
Because the situation was so incredibly dire, the court granted the family rare, direct access to immediately rule on the constitutionality of both the act and the regulation. Now, direct access isn't commonly given, but three factors made this exceptional. The urgent need to unblock all those frozen estates, the fact that the laws were so manifestly discriminatory that no extensive evidence was needed to prove they were unconstitutional, and the fact that both the Minister of Justice and the Master fully supported the swift intervention of the court.
Adding to the urgency, the Women's Legal Center Trust joined as an amicus curiae, a friend of the court. They pointed out that this two-tier system didn't just discriminate based on race, but it intersected heavily with gender and culture to disadvantage African widows. The procedures under the Master's office actively protected widows and allowed them to participate in choosing executors, whereas the old magistrate system left women and children of customary unions in an extremely vulnerable position.
Let's look at Section 5, a just and equitable solution.
Let's see how the Constitutional Court actually built a pragmatic, surgical fix to this massive dilemma. First up, Justice Sachs made it unequivocally clear that these laws were an absolute affront to dignity and entirely unconstitutional. He stated they were antithetical to a non-racial society where rights and duties are no longer determined by origin or skin color. He officially ruled that treating people differently simply as blacks constituted unfair discrimination and totally violated the inherent right to dignity.
But to prevent a system collapse, the court knew they needed a phased approach. They instantly invalidated Section 23(7), which officially empowered the Master to administer these estates. However, they suspended the invalidation of the magistrates' powers under Regulation 3(1) for 2 years. This meant the magistrates could still legally function, preventing the Master's office from being crushed by that terrifying backlog of 66,000 cases. And it gave Parliament a strict 2-year window to rewrite the laws safely and create a unified system.
And here is my absolute favorite part of the ruling, a literal legal hack. By changing one single word, the court transformed a racist mandate into a temporary option. The regulation originally said black estates shall be administered by the magistrate. The court ordered that, during this 2-year suspension, the word shall must be read as may. Why does one word matter so much? Because by shifting shall to may, black families were no longer treated as subjects without agency. They were given the dignity of choice while the broader system was being fixed. Magistrate jurisdiction became permissive, not exclusive. If a family wanted the Master of the High Court, they could go there. But if a family with limited means preferred the cheaper, more informal, and geographically closer magistrate system, they still had that option during the 2-year transition. So, what about the Moseneke family? For them, this meant they finally received the equal treatment they fought so hard for. The Master of the High Court in Pretoria was officially ordered to administer their father's estate. Their pursuit of dignity not only resolved their own painful situation, but ended up unblocking the system and paving the way for a more equitable legal framework for literally thousands of others.
It leaves us with a really powerful thought to take away from this explainer today. Achieving true justice isn't just about destroying bad laws. It's about the careful, often super complicated work of building fair systems in their place. When the law touches the most vulnerable moments of our lives, like mourning a family member, how do we ensure that the transition to justice doesn't accidentally cause its own harm?
It's a delicate balance for sure, and one that requires both constitutional idealism and administrative pragmatism. Thank you so much for joining me, and I hope this deep dive has given you a brand new perspective on the mechanics of justice.